Good morning, this is your Kelso Report for Thursday, September 6th, and I'm your host, Clark Kelso. Well, we have two cases today, and both of them involve constitutional issues. The first involving a city council's ability to regulate disruptive speech and conduct at a city council meeting, and the second involving the constitutional protections that a homeless person can claim in his or her temporarily unattended personal property. First, we go to the city of Costa Mesa. Section 261 of the Costa Mesa Municipal Code makes it a misdemeanor for members of the public who speak at city council meetings to engage in, quote, disorderly, insolent, or disruptive behavior, close quote. The plaintiff in Acosta versus City of Costa Mesa had been removed from a Costa Mesa City Council meeting for an alleged violation of the ordinance. He sued for damages, arguing, among other things, that the ordinance was facially unconstitutional under the First Amendment. The district court dismissed the facial First Amendment challenge and granted partial summary judgment to the defendants on other claims. The jury then rendered a defense verdict on the remaining claims. The Ninth Circuit affirmed, in part and reversed in part. On the First Amendment claim, the panel held that Section 2-61 was overbroad to the extent that the word insolent improperly extended the ordinance's scope to include protected speech or expressive conduct that did not involve an actual disturbance to the city council's meetings. Now, it is easy, I think, for us all to see that you can be insolent in speech without being disorderly or disruptive. And if you can't be insolent to your city council at a public meeting, to whom should you direct your insolence? Nevertheless, the majority of the Ninth Circuit panel also found that the word insolent was easily removed from the ordinance without detriment to the legitimate purpose of Section 261 of maintaining order in council meetings. And so, the ordinance need not be wholly invalidated, since it was, taking out the word insolent, properly applied to the plaintiff's actually disruptive behavior. Next, we have a case involving the personal property rights of homeless people, coming to us out of Los Angeles. One of the problems created by a large homeless population within a city is that homeless persons have personal property that also doesn't have a home. And when that property begins to accumulate on sidewalks and public thoroughfares, public health and safety concerns may require that action be taken to seize and remove such property. Well, in Los Angeles, the city began a program in the Skid Row district of seizing and immediately destroying the unabandoned personal possessions of homeless people when the possessions were temporarily left on public sidewalks while the homeless attended to necessary tasks such as eating, showering, and using restrooms. 9 of the homeless individuals sued, claiming that the seizure and destruction program violated their 4th and 14th Amendment rights. The district court granted a preliminary injunction, finding that the plaintiffs were very likely to prevail on the merits. The district court enjoined the city from confiscating and summarily destroying unabandoned property in Skid Row, although the injunction permitted seizure and removal, but not immediate destruction, of any property that actually presented an imminent threat to public health or safety, or was evidence of a crime, or was contraband. Nevertheless, the city appealed, seeking a much broader ruling that it might seize and immediately destroy any personal possessions, including medications, legal documents, family photographs, and bicycles that are left momentarily unattended in violation of the municipal ordinance. Rather remarkably, I think, the city argued that the Fourth Amendment simply does not apply at all to its program, since the property being seized and destroyed was in plain view on a public sidewalk. Well, a majority of the Ninth Circuit panel in Lavon versus City of Los Angeles rejected this position and upheld the injunction. A homeless person does not lose the protections of the 14th Amendment just by virtue of having to live on the street. The dissenting judge on the panel concluded that society does not recognize a property interest in unattended personal property left on public sidewalks, and so agreed with the city that the 4th and 14th Amendments simply do not protect a homeless person's possessory interest in unattended property, particularly where there are posted signs warning that unattended property will be seized and destroyed. But for the majority, rights in personal property could not be so readily and so easily ignored. And that's it for today's Kelso Report. Have a great day in the law.